Yo, 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 yo. Appreciate it. Appreciate it. Peace, love, and law, everybody. Welcome to In God We Trust Academy podcast. Tonight, hope everybody's having a great and beautiful day, man. We just here to deliver some great information for you guys. Where y'all tuning in from? Like, share, and subscribe. Drop some ones for us. We got something we want to share with y'all. Yeah. On this good old Sunday. Our duty is just to keep informing the people. Keep informing the people. What's going on, Brian Langford? How you doing? How you doing in Maryland? Brian said he is in Maryland. All right. Drop your ones, drop your ones. That's what's up, man. Glad you're doing great, man. Glad. Ain't nothing like doing great. Real talk. Know you in good health, your people, children. Got a few more minutes before we get started, guys. All right. Man, for whoever is here right now, tuned in and locked in with us, man, this is specifically for you. Yeah, the universe has brought us together for you to hear this special message that we got for you tonight. As always, we give thanks for each and every last one of you on your participation here with us at In God We Trust Academy podcast. We give thanks to the Most High for all things that have taken place, and that we just continue to move forward and press on, have perseverance, be consistent, and hey, guys, never give up, yo. There's not a time to give up. When we have seen so much, how can you even lose faith after all you've been through? You know, keep pushing. That is the main thing. So always thankful for you guys. Everything you guys hear from this point on is for educational and religious purposes only. Anybody seeking any form of legal advice, please do seek a legal advisor, as it is my religious duty to speak my religious truth and experiences here with you guys again. Right? And listen, today, I'm just preparing you guys for the upcoming class on October the 25th, 2025. That's coming up. And it's paid in full. And it's where I literally took a $25 money order, guys, and used the procedure of a court of satisfaction, a few other things as well, and literally got my title free and clear. All right. Made them settle out of court. And you can do this too as well. There has been so much that I have added to this and tweaked along the way because I've done this a few years back. So I've learned tremendously amount more since then in operating in procedures in courts. But I'm just giving you the top tier knowledge of what I have at this moment. So you don't have to go what I went through at that time. But tonight, I'm going to share with you that petition that just grabbed them by the neck and made them declare at that moment that, hey, we got to give this guy what he wants. There's nothing we can do. So I'm going to speak on to you on how a petition should look. Now, what you're seeing on my screen, if you're able to, if you're on TikTok, you're not, you're seeing a different screen right now. But for those of you who are watching, you see the paid in full ebook popping up. And then you see a title pop up. That's the title that we got free and clear. And then that is me speaking with the lawyer of this particular bank and letting you know that they were going to settle. And so they sent us letters, let us know, and we made it happen. So I'm going to speak to you guys today on what that would look like when it comes to you, okay? And if you are ready, drop some ones, hit the share button, like and share. We're going to make it through this song right here, and then we're going to keep it pushing. Gonna make sure y'all get this knowledge today. Like and share and subscribe. I ain't going till you're doing. Drop some ones after you have done it.
I've been through the rain.
If you're really ready for it.
I've been through the pain and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. I've been through the rain. I've been through the storm. I've been through the pain and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. All of the pain inside, it's hard to let the shit ride. Homicide, why they take my nigga life? Seems I got some shit with my family. I'm trying to
Let's go, family.
2 daughters, 2 mother, 2 family.
Hit that like button, hit that share button, man.
I keep that shit they kill for. Trying to kill my spirit, yeah, my music.
If you here right now, this is for you. I'm gonna show you how to get that title to that car.
Tell me why me when I'm really trying to build some.
If you're ready for it.
Little bitches set me up, huh? Should've killed them
Yeah.
niggas since then. I done triple boy. Probably 25 to life. I pull it from my hip. Yeah. I've been through the rain. I've been through the storm.
Let's go.
I've been through the pain.
Drop your ones, man. Let me know
I bet the sun
that you in here with me
gon'
tonight.
I bet the sun
Some of y'all
gon'
acting like
shine
y'all scared, but it's okay.
I've been through the rain.
We're gonna keep pushing.
I've been through the storm. I've been through the pain and it's hard to stay calm. Yeah. I bet the sun gon' shine on me. I bet the sun gon' shine on me. April 11, I lost my pops.
Few more
10
minutes,
months
family.
later, my daughter
Now we
dropped.
about to drop
You
it today.
can't tell me life can't transform.
Hey,
And you can't tell me that I ain't the one. I done took blows with friends and family. I done made money with friends and family. When you get broke, just watch I can handle it. It's time to ride. And niggas ain't down for you find that fire. And then you start racking, you find that plug. And then you start stacking. And niggas is robbing. You better stay packing. Ain't doing no talking, just know it's by action. Saying you love me, give me expression. We don't take pleas, ain't doing no confession. Nationality, I swear it's a blessing. Knowing I'm a king and I got the recipe. Give me the keys. You know I'm gonna run it too far in the game. Ain't doing no front. Let's get to this money. You
Yes, sir.
LRP and we way up in God.
Is y'all ready, man? It's time for the sun to shine on you right now. Knowledge, information is power, and how you apply it, family. How you apply it matters all day. So let's get ready to jump into this. I want you to listen very closely because this is a direct petition that if and when you come and take this class and you done your procedure correctly and done everything, then this petition right here is going to sail the ship for you to walk away with your title. And that's all it's going to take. That's all it's going to take. And that's all you need to do. Simply. So, you guys are ready for it? Let's do it. If you guys are ready, let's do it. Okay, so with this, this is from myself versus a bank. So the plaintiff here brings this action against this bank. We'll just say the bank. And it's for a declaratory, injunctive, and monetary relief arising from the defendant's continued collection activity and credit reporting and accepting after accepting and negotiating a negotiable instrument expressly tendered in good faith in accord and full satisfaction for all debts and performance obligations. Plaintiff seeks a judicial declaration that the underlying obligation has been discharged under Alabama Code 7-3-311, an injunction compelling defendants to release the title to the automobile and to update all credit reporting to show $0 in balance and statutory actual damages under 15 USC 1692 KD, compensatory damages for financial loss and emotional distress, and costs and other relief the court deems appropriate. So that is just the preamble. So now we give the jurisdiction and venue. So the court has federal jurisdiction under 28 USC 1331 because the plaintiff asserts claims under Fair Debt Collection Practices Act 15 USC 1692 and in sequence. This court has diversity citizenship under diversity jurisdiction, under 28 USC 1332 because the plaintiff is we can say the plaintiff is in one state and the defendant or the actual national bank, actual headquarters, it could be in California, Tennessee, wherever, right? And the amount in controversy, including request damages, exceeds $75,000, right? Because we got to get you. We got to get you. So the court has the authority to grant the declaratory and injunctive relief under 28 USC 2201 and 2202. Venue is proper in this district under 28 USC 1391B because the events giving rise to the claims occurred in a specific county and state, right? So now, with that being said, now we have just given jurisdiction and venue. So jurisdiction has been established, okay, in the full amount here. So we have the subject matter, we have the parties involved, and since they're being summoned, this also gives a form of personal jurisdiction here for the courts as well, okay, based upon the parties involved and the contract which has taken place in a certain form of territory. So that allows us to do certain things in a way that we're going to ensure that we win. All right. Everybody make sure y'all can hear me loud and clear before we continue. Let me know. We good and clear? How is it on y'all side? I want to make sure it's good. So we have established the jurisdiction. That's done. Now we talk about the parties. The party individuals, one in particular, we'll say city, county, and state. And then the defendant, the bank, is a National Bank Association business in the state of wherever, and which does business. And you can say, we'll say for this particular matter in Alabama, right? So now the factual allegations is where we at. So what are the factual allegations here? Okay, so now we can say on or about March the 24th, 2022, plaintiff prepared and mailed a U.S. Postal Service money order. You'll put the money order number in the amount of, we'll say, how much ever it was. So you could have did the full amount and included in statement in good faith and accorded and full satisfaction for all debts, performance, and obligations. The money order was mailed to the address specified by defendants for payments and was sent in the USPS tracking number. Defendant received and negotiated the money order on or about March 26, 2022 under Uniform Commercial Code, a negotiable instrument accepted in full satisfaction of all claims, operate as an accord of satisfaction if tendered with the required language and accepted under this particular code. So under Alabama Code 7-3-311. Apply to negotiable instruments tendered and negotiated in these particular circumstances here. So after accepting and negotiating the money order, the defendant continued to issue billing statements and collections communications regarding the same account. So including statements showing a payoff figure and monthly amounts still due, right? So now we said as of October the 28th, 2022, defendant's most recent billing or payoff statement showed a payoff balance of $9,200 some dollars, and the defendant continued to report an outstanding balance on the plaintiff's credit report. To prevent repossession and further collections pressure, plaintiff made an additional voluntary payment to the defendant, including a payment of $400 on September. In September, so defendant threatened or communicated potential repossession as a result of the account status after receiving the money order. As a result of the defendant's continued collection activity and reporting, the plaintiff suffered financial loss, including funds drawn from personal trust resources, damage to credit reputation, emotional distress, and loss of time addressing the dispute. On or about September 9th, plaintiff provided written notice to defendant stating the money order constituted a court of satisfaction and demanded that the defendant mark the account paid in full and release the title. Defendant has not released the title and continues to assert the existence of debt on the account ending, and you'll put the end of the account. Plaintiff alleges that the original note and security agreement associated with the subject account were securitized or otherwise removed from the defendant's possession, and the defendant is unable to produce an original negotiable instrument that would be required to enforce the debt pursuant to UCC Alabama Code 7-3-301. So plaintiff further alleges that if the original note was securitized or destroyed, then under 7-3-604 of Alabama Code, the instrument may be deemed discharged or defendant lacks the right to enforce the instrument, which supports the plaintiff's claim of discharge and lack of enforcement standing. Defendants continue collection, false reporting, and refusal to correct the account after acceptance of the money order constitutes unlawful practice under federal and state consumer protection laws as alleged below. So you got count one. So under count one is violation of Fair Debt Collection Practices Act, and we'll say plaintiff incorporates by reference paragraphs 1 through 22. And it says defendant engaged in repeated telephone calls, threats of repossession, and other conduct intended to harass or abuse plaintiff in the effort to collect the debt after the debt was discharged by a court in satisfaction. Defendant's conduct, as described above, constitutes harassment and abuse in violation of 15 U.S.C. 1692D. As a proximate result of the defendant violations of 1692D, plaintiff has suffered damages and is entitled to statutory and actual damages under 15 U.S.C. 1692. Okay, so now we got that. Now we also got a violation of another violation is based upon false or misleading representation. So we can say they made false or misleading representation concerning the character and legal status of debt by presenting that an outstanding balance remained due after the defendant accepted the negotiated money order till tendered in full satisfaction. So now that conduct describes above violates 15 U.S.C. 1692E and its subsections including E2 and A and E10. So now, as an approximate result of the defendant violations of this subsection, plaintiff has suffered damages and entitled to statutory and actual damages under 15 U.S.C. 1692. Okay, so we got him in a headlock. This is also breach of accord and satisfaction, which would literally be the new contract because they fully agreed to it, right? So that's a breach of contract. So we tendered in full satisfaction. The defendant, the instrument was offered in full satisfaction. He was notified. The defendant received, negotiated, and accepted the instrument. Acceptance and negotiation of the instrument established an accord and satisfaction. Now, what does it mean by they negotiated? It means they cashed it. So in order for them to do that, they would literally have to sign their name on the back or literally put pay to the order of and then send that off to someone else to cash. Either or, it was cashed, right? So that means they accepted. So now acceptance and negotiation of the instrument establishing accord and satisfaction discharging the underlying obligation to the extent of the tender to pursuant to Alabama Code 7-3-311. So defendant's subsequent demands for payment and continued reporting of balance constitute a breach of accord and satisfaction and are wrongful as matter of law. So as an approximate result of defendant's breach, plaintiff has been harmed and is entitled to declaratory relief. But not only that, we gave them 30 days. So that also has to be implemented. So if 30 days was given and then they didn't dispute it at any time during those 30 days, then that means they fully agreed and their statute of limitations was fully reached. So there you go. Because the court is going to want to know why. According to statutory law, why did you not fully? And that is literally equity. Because a lot of people don't even understand what equity is. You would think that, that's statutory law. It's not equity. Yes, it is. Because under that statutory law, I'm looking for a specific performance. And this their performance. So the judge has to do what ought to be done, what is righteous and what is fair. So if they did not rebut in 30 days of the time or of the statutory limitations that's on it, then what happens is the judge has to agree with me in equity, because that's what ought to be done. That's what's fair. That's what's just, right? So there you go. Now you got the declaratory relief. You want an actual controversy exists between the plaintiff and defendant as to whether the money order and the facts surrounding it constitutes a complete discharge of obligation. And you want to seek the declaration that the subject obligation has been discharged by a court of satisfaction and the order defendant mark the account paid in full and correct any credit reporting reflecting otherwise. So then you got an injunctive relief here because we want to stop everything until this is handled. We will suffer irreparable injury if the defendant is not compelled to release the title and cease collection and reporting, because your credit, reputation, and property rights will continue to be injured. All right, you want to request an injunctive relief to compel the defendant to release the title to the actual car, correct our credit reporting to zero, and inaccurate derogatory information, cease all further collection activity, and discharge the account. And that means also any form of attempts to repossession as well. Then you got count 6, fraud and misrepresentation. So again, all of this that they're reporting on you, everything that they're doing, even acting like it's a debt that still exists, that's part of it as well. I'm not going to read all of that. But then, then we go into our damages and preferential relief. So remember, truth, proof, law, and relief. You also make sure you have your full exhibits and then there. But here's the thing. I like to play the devil's advocate a lot. So this is how you make yourself better. If you were on the other side, how would you respond to this? Right? So let's say if I was the bank and let's say if I was an attorney for a bank or something, how would I respond? And I would say something like, okay, the defendant admits that the plaintiff has filed this civil action seeking declaratory injunctive monetary relief arising from the alleged accord and satisfaction. The defendant admits it receives the postal money order for $20 dated March the 23rd, 2022, and applied it as a partial payment on the plaintiff's automobile loan. Defendant denies that the instrument or any notation thereon operated as a discharge of the loan balance or that the defendant agreed to any accord of satisfaction. But the truth is, you cashed it. You agreed. So, defendant denies that it violated Fair Debt Collection Practice Act or any other law, denies that it is a debt collector as defined in 15 U.S.C. 1692A and 6, and denies that the plaintiff sustained any cognizable damages. Defendant admits that it is a national banking association with its principal place, wherever, and admits that the plaintiff resides in Alabama, except as expressly admitted, defendant denies each and every remaining allegation and demands strict proof thereof. Okay, so they want strict proof. So that means count 1, defendant is creditor collecting its own account and is not subject to the FDCPA. Any communications, which that's wrong, with plaintiff were lawful and limited to routine loan servicing. Then they said the defendant, they could say something like defendant accurately reported and balance owed and never made any false representation about the status of the loan. The loan contract and retail sales agreement expressly require payments of specified installments and prohibit modification except by writing signed by a defendant. A $20 money order cannot constitute a new agreement discharging a balance of more than $9,000. Defendant did not agree to accept the money order as full payment and did not intend in accord of satisfaction. So they could say something like that. But all of this we already got the proof of. So here's the thing, because they say that they wouldn't notify. We send a letter with it. You always got to make sure you send a letter with it. So that's why I say if you do this procedure right, you can kill everything that they could possibly say. And that is how you build your best offense, by knowing the best defense that could stop the offense, which will help you create an offense when that there's no defense for it, right? Because you have all truth, proof, law, and relief. So now, declaratory, they'll want to deny that because no accord of satisfaction occurred. They could say fraud and misrepresentation, made no false statements or material facts, all communication accurately reflected the account status. And they could say you failed to state a claim. So complaint fails to state a claim upon which relief can be granted. So basically saying there's no subject matter here. So they saying that none of that exists. There's no subject matter. So therefore, there's no complaint to grant relief here. So now, arbitration and contractual bar. Plaintiff's loan agreement contains a binding arbitration clause and class action waiver covering all claims arising from the loan. But if the accord of satisfaction happened, that means that the original duty is no longer there and that the new contract is the accord of satisfaction. So good faith and compliant, all acts of the defendant were taken in good faith in accordance with applicable law and regulations. No accord of satisfaction. The money order was unauthorized to attempt to alter loan terms. Failure of consideration, no valid consideration supported any new alleged agreement. Then they'll say statute of frauds, lack of damages, plaintiff's own breach and failure to mitigate because they want you to go into loan. Unclean hands, plaintiff seeks an equitable relief while in default without having performed his own obligations when you have. So look, those are just the things they'll try to say. So make sure you do what you're supposed to do. But what would you put to that? First and foremost, what you're going to do is we're going to shut their mouth right now, because this is where we hit them at. We already got the complaint rolling. We already got proof of that. So since they want to act like they're still the alleged creditor, you owe, you in default, you are, okay then, buddy. So now you are requested to produce the following documents for inspection and copying at the office of the plaintiff or plaintiff designated agent within 30 days after service of this request. These requests are continuing in nature and require supplementation as additional responsive documents become available. So this is where we hit them, because now it's time for the discovery. Okay, we had that complaint. They had their answer. So let's roll into the discovery, because we're like, okay, well, look, okay, then we heard what you said. So now we say document means any written, printed, or recorded material, including electronically stored information. Account means the automobile loan account ending in whatever it is. And note means the reinstalled contract or promissory note executed by the plaintiff for the particular automobile. So number one, request original note and allonges. Produce the original wet ink promissory note or retail installment contract for above reference account, together with every endorsement, allonge, an assignment appearing on or affixed to the instrument. That's what we want to see. Now, we also want the chain of title and ownership. Produce all assignments, sale agreements, pooling and servicing documents, and custodial transfer records that evidence any transfer, sale, or securitization of the notes. And then we also want servicing and collection authority. So produce every agreement, power of attorney, or servicing contract authorizing defendant or any affiliate to come collect payments on the account after its origination. Now, we also want to know if the original instrument has been lost, destroyed, or is otherwise unavailable, produce a lost note affidavit complying with UCC 7-3-309, including identification of the custodian, the circumstances of loss, and any indemnity bond posted, because they gotta post a bond for that, to stop any form of harm or damages. So request here, payment history and application of money order. Produce a complete payment history for the account showing how the money order was received, endorsed, negotiated, and credited. Request number 6, communications and collection records. Produce all internal notes, call logs, and correspondence relating to collections attempts or credit reporting on the plaintiff's account March 26, 2022. Request number 7, credit reporting submissions. Produce copies of all data defendant furnished to any consumer reporting agency regarding plaintiff for account between March 26, 2022 and the present. So we also need policies and procedures. So produce the written policies and procedures in effect during this time, governing the acceptance of payment marked in full satisfaction and handling of accord and satisfaction disputes. We need all of that, right? We need all of that. Yeah, the slideshow is the only thing you're supposed to see because that's the proof. What you hearing is what I did to show you the proof, but here's the proof. So now we need all of that. So now after we hit them with that motion, now we also have to reply back to their defense. So we want them, we're going to reply back and hit them with the motion. Okay? So now we're going to say, okay, here's our reply here then, buddy. So failure to state a claim. Defendant admits receiving and negotiating negotiable instrument. That's the first thing they said, right? Those facts, taken as true, state a claim for relief under both UCC 7-3-311 and 15 USC 1692 D through E. The complaint therefore satisfies Federal Rule Civil Procedures 8A. Arbitration clause. Once defendant accepted the accord, the prior retail installment contract was replaced by a new contract, the accord itself. The arbitration clause in the superseded contract no longer governs. It's over. Okay? Good faith. The record shows deliberate post-discharge billing and credit reporting, a bona fide error defense under 15 USC 1692 KC. Fails where the violation is intentional or repeated after notice as here. So we've already gave you notice and you continue to make these reports. We've already proven that you accepted something that was fully discharged in all obligations. We tried to settle this matter. So now you're intentionally doing it no matter what, even after giving notice. That right there is what we're talking about. So now when it comes to the 16th defense, not a debt collector. Even if defendant is a creditor, it used its internal division to collect a consumer debt and communicate it by phone and billing statements. The FDCPA applies to such conduct when the entity uses a name other than its own, 15 USC 1692 A6 as well. So no accord and satisfaction here. Lack of consideration. Defendant's own admission that it received and negotiated the money order with the legend in full satisfaction satisfies three statutory elements of accord: a bona fide dispute, a tender in full satisfaction, acceptance. Consideration exists because plaintiff tender extinguished defendant's right to continue collections. Acceptance of that benefit constitutes consideration. So now when it comes to statute of fraud and written modification, the UCC governs negotiable instruments, not the common law statute of frauds, right? So now, subsection 3-311 expressly allows discharge by written notation on an instrument. The required writing is on the face of the instrument itself, but we also gave a letter, a notice. So unclean hands, plaintiff mitigated damage by making additional payments only to prevent repossession and by sending written notice of the discharge. Those acts demonstrate good faith, not unclean hands. When they say statute of limitations, FDCPA's 1-year period began on the date of each unlawful collection communication. All alleged violations occurred within 1 year of the filing. So again, on each, notice it said on each unlawful collection communication. So every time they did that, it's a year from there. So yeah. Defendant answers and admits the receipt here that the applicable statutes speak for themselves and that it continue to serve as the loan. Also, the admissions meet the prima facie elements of accord and satisfaction. No further discovery is needed to establish discharge as a matter of law. So now they already admitted. So now we can move to a plaintiff motion for partial summary judgment. So we can move the court. The material facts are disputed. Plaintiff tendered a negotiable instrument labeled in good faith in accord and full satisfaction. Remember, they admitted that. Defendant received and negotiated that instrument. They admitted that. Defendant did not return or repudiate the instrument with a reasonable time. They also admitted that. Defendant continued to pursue collection and credit reporting after acceptance. They admitted that. So now the summary judgment is appropriate when there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. When a defendant admits receipt and negotiation of a payment tendered in full satisfaction, no factual issue remains as to whether the acceptance occurred. So the facts is it was mailed to them. The face of the money order contained those conspicuous statements. The defendant negotiated the instrument. The defendant neither returned the instrument nor notified plaintiff that it will not accept it as satisfaction. Right? The undisputed facts established and accord of satisfaction. So under that, when a person against whom a claim is asserted tenders an instrument in good faith, full satisfaction of claim, and claimant obtains payment of instrument, the claim is also discharged. So now we got that. Defendants continue collection after discharge, violated the FTCPA. So anytime they made a call, sent a letter, made any type of threats, that also applies. So that's what we want. So now in the relief, we want to grant to a partial that the obligation was discharged and order defendant to mark the account paid in full, release the title, enjoin defendant from further collections or adverse credit reporting, reserve remaining counts. So we can reserve the remaining counts for later trial or settlement conference. So we already got those. We get the title. We automatically know they accepted this. It is discharged. Now we're just looking at punitive damages. So we want them to rule on their part. They'll rule in our favor. We already halfway won the case. Now we can say the rest of the counts for later for trial because they already had admissions, right? So that's just to give you an idea of how it can go for you. Guys, this is also, everything that I just said is also included fully into the ebook as well. So do know that. All right. Everything is included in this ebook. So if you are interested in this, because this is great. This is a great thing to know, a great thing to do. And as I told y'all, you play up on the weakness of corporations because they are very. And that weakness is their arrogancy and the fact that they think and know that or feel like you are ignorant and you don't know anything. Right? So now they got two things to do. Because up on that, we did a motion for production. So they still got to produce these documents. And they got to still answer to what I said. So they got to do something about this partial judgment. Because we got the right. They already admitted. So if they admit, and they're going to have to admit, because this is going to show proof. And you're going to put into your proof. Your proof is going to be the letter that you sent. Make sure that you take a picture of the letter. Or make copies of everything. The letter, the money order itself, just everything implied. Make sure you take pictures of exactly what you wrote, what you sent. Send it in the right manner that you're supposed to send it. And when you do this right, and it makes it to them, and they accept it, because some of them are, I'm telling y'all, I promise y'all, they assholes. Yeah, we got there. They will literally say, yeah, we got your letter and we don't care what you said and what you're trying to say. Yes, we cashed it and you still owe us. You're going to pay us. You're going to run into some people like that. Now, you're going to run into some people who will just send the money, send it back to you. And that's smart because that's what they're supposed to do. That gives them time to dispute it. But what you do is you just sit back and you wait and you send it again. It don't hurt nothing to make an offer, guys. And you just keep attempting until they actually take it. Because once they take it, and it's done. So, but you pay it the regular way, and then you try it again. And then you try it again. And then they're eventually going to do it. Now, the one who's going to be the most aggressive is going to be the easiest ones to do it with. Because the ones who's coming after you, trying to repossess some, trying to foreclose on you, trying to do this, trying to do whatever, they're looking to accept any form of payment from you as quick as possible. So even when you get on the phone, you got to just know how to talk. Start talking to these people. Right? And make sure you're recording. And just say, okay, yeah, yeah, okay. Yeah, I just want to make sure that I can make this payment in full, in accord and satisfaction of full obligations, and everything is all fully discharged, right? That's what I want to make this payment for. Okay, yes, ma'am, you can make a payment. That's all they're gonna think of. They ain't gonna really listen to what you're saying. It doesn't matter though, because it's the phone call is what recorded. And they're going to let somebody collect a debt or accept something on their behalf, they might want to teach them something because other than that, they're in trouble from that point forward. We're going to get them and we're going to easily win. But like I said, the easiest ones are the ones that are aggressive towards you. And those are the ones that you owe. And you know how people get. They get aggressive when you owe some money. So use that aggressive against them. They're like I said, they're so eager to want to get some money. And you get on that phone, and all you gotta do is have conversations. Okay, well, yeah, I'm gonna do this, I'm gonna do that, or whatever, however you do it, and send it. And just wait. Cause they're gonna take it. And the next thing you know, it's gonna be cashed. And when you see it's cashed, it's yours. You win. Automatically, you're going to win. All right. But you got to understand the rules. You got to make sure that you do this right. That's what matters the most. And the thing about law is this: just literally read the law, do everything that is said within it so that you have great success and become prosperous. That's all it is to it. Like, and that's the thing about law. It's just like do A, do B, do C, do E, blah, 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 blah. Like, it's just on and on. And once you do it, even when it goes into the court, follow the right procedures, do everything right, and that's it. The court's is not my strongest suit. I'm definitely interested. Right. So, and that's the reason why I'm explaining in this actual ebook as well that's going to come with the class, just to give you a flow of how it's supposed to go. And you can start seeing that. But that's the reason why I say make sure that we get into, if you want the VIP section, we're going to be doing a workshop, a 3-hour workshop, making sure everybody fully prepares their documents, making sure that you got everything the right way. So, because like what you have really is a script, and you can make sure the script runs that way in the way that you want it to. So what I'm saying by that is, like, let's say that you first decided to, you send a letter, you do everything that you know you're going to do. They accept it. All right, boom. When they accept it, the key to this is, it's like, you got to understand, keep your mouth closed. You don't say anything. But you got to make sure that you have the right words, the right things on there to say, and being able to fully prepare yourselves to operate. Right? And that's where a lot of people are going to lack at. Like, it's easy for y'all to get a template and push it, but can you go into court and still exercise what does it mean to do something under this particular rule? And the fact is that instrument is governed by this particular rule of law. You get to set how that instrument is going to be used and how it's governed if someone is to accept it for the face value of it, right? And the part of the statement is part of that face value based upon how it's going to be received, because it also deals with obligations. So this is discharging obligations that is in relationships to it, as well as the debt. So if you do that, and when you do that, again, it's just up to you to know how to enforce it to the fullest. Have all of you got to be a good record keeper. Everything has to be in full order. And as you can see, even if, as you're seeing on the screen, like, I definitely received mine and made them settle out of court. Now, what y'all getting from me is what I'll say about just what I learned from that, like what I put into the petition at first, like, and what I know now, I could have got that done. I could have got that done the day they probably even got a lawyer. The first day the lawyer realized that this was filed in court, they would immediately hit me and say, hey, we want to settle out of court. And I know that. But that's then, you know what I'm saying? The way I did the petition then, it wasn't what I pretty much know as much as when it comes to court procedures and stuff like that and how to maneuver. But then, like, I had started learning throughout the procedure of filing this civil complaint. And when I did, I was like, oh, okay, I get what I was supposed to do. So I actually took a complaint, sent it, and I amended it to a certain point. I answered, and I said, like, all of these different things in it. And, yeah. And I realized some of the things I was saying in it should have been actually in the first original complaint. And if I would have did that, then I wouldn't have to deal with any of that at all. So that's what you guys are going to be getting from the very beginning. So what I read to you is a lot of what should have been in the complaint from the beginning, and then learning how to next move into the step of discovery. Because if I go literally right from I give the complaint, they give an affirmative defense or answer, and after that, we go right into discovery. So I want them to produce these certain type of things, because in their defense, they were saying that they're the creditor, they got this, they got all of that. So, okay, well, let's go into discovery. Prove it. Prove you have this, and that, because I want you to produce these things. I also need you to produce everything dealing with the note, and I also need you to do everything dealing with you acceptance of this particular accord of satisfaction. I need that because once I get that, your ass in trouble. You is in trouble. And that's what we win at. We're going to get them every single freaking time. And it's no loss. You know, we're not going, you can't lose, guys. And the reason why I tell you can't lose is because I've already done it. And if I already done it, I'm showing you the proof that I've already done it. There's already a pathway for you to do it. You just got to exercise with it. And here's the thing, you know, it's just about these people knowing what they're supposed to do. So if they know to accept or not accept, then don't. Then, but again, just go on to the next. It could be done with a utility bill. It could be done with a mortgage. It could be done with a cell phone bill. It could be done with, I don't know, name it. It can be done. But you just got to be willing to step in and actually do the work and understand exactly what you're doing. But after you get done reading this ebook fully, you'll know exactly what's what, okay, what to do. You'll learn the nature of debt in modern commerce. You're going to learn the concept of accord and satisfaction. You're also going to learn how to resolve disputes without endless litigation. And you're going to understand common law and Article 3, how to use that. You're also going to learn the role of dispute, okay? What you must establish that the debt is in dispute. So why you must establish, you have to learn to establish the dispute first. The dispute has to be established, okay? And once you establish the dispute, we can move forward. Now we got to have the proof, which is building the record. So after we done everything, you're going to learn how to do a notice of adequate assurance, how to write that up specifically, okay? What that means and what to do with that. And then you can also learn how to draft a notice of accord and satisfaction. Show you how to do that. How to write on the instrument what should be written on the actual money order to make sure to follow. Make sure we send to the correct address. If there's a special place that things are supposed to be sent to, certain things are supposed to be sent to when making certain forms of payments, then or special payments or stuff like that, then you make sure that you send it directly there. All right. If no special address is provided, send it to the address normally used for payments. You're going to learn that. The conspicuous notice, make sure that you point that out. We're going to teach you that. Also, you're going to learn to why acceptance matter, how to reserve your rights, and they have to learn that altering or ignoring the ledger. So that's going to be real strong. I'm going to teach you everything about case laws that's going to back you up. You also got a full evidence package. Once you get it, you got to make sure you operate it right. So now we're going to move into the law itself. So you'll learn all the laws that's going to obtain to exercise. And again, you just got to follow the law. Then the relief itself. What are the effects of accord and satisfaction? What are the effects? And that's what you're going to learn as well. So again, there's a adequate assurance template in here. There's also a notice of accord and satisfaction template in here. There's a what to put on the money order in here. What else you got? Petition to enforce accord and satisfaction. So that's one. I think I put another one. I put like a couple in here. Motion to dismiss if you have to go to court. Let's say they brought you to court instead of you suing them. You can literally do a motion to dismiss and place all of your evidence with it on why the case should be dismissed because it is discharged, right? So I'll show you how to do that. So either if you take them to court or they take you to court, that will be shown both ways. And then at the end, I just put like some extra stuff to it. But it's fully loaded, man. Hey, fully loaded. What about when your state doesn't have accord of satisfaction because New York doesn't have it? Well, I guess y'all shit out of luck then. That's all I know to say. If y'all don't got it, y'all out of luck. figure out something else, which there's other ways I can show you. Other ways. Any questions though? Any questions? Anybody got any questions? If your state don't got it, my bad. I ain't nothing I can do. But any questions though, for sure. I will definitely answer to the best of my ability. So it says New York law recognized the darkened accord of satisfaction. In other words, new agreement. And it says statutory basis, New York's general obligation law, Article 15, Title 5, is titled Accord of Satisfaction and set out rules for executory accord and offer of accord followed by tender. You might need to go read your laws. I don't think you know what you're talking about. Because it also says offer and tender, let's see, under 15503, an offer in writing to accept performance in full or partial discharge of claim, in other words, accord, followed by timely tender of that performance may be used as defense even if the offer is not accepted. So unliquidated disputed claims, typically doctrine of accord and satisfaction is applicable only when the original claim was unliquidated or disputed. So oh yeah. So they do have it. You just have to understand the law of what they're trying to tell you. You can find it. The court. So, and here's the thing to all you guys. This is what you're talking about when it comes to this class. It's paid in full. So this is the paid in full class that we're talking about. But if you feel like court is not your strong suit, then the mastering lawsuit class. Okay. And so what I will do, I've been thinking about it. I ain't decided yet if I want to actually give it to the students of this class. I think I said I would earlier, but I don't know. We'll just have to make sure. I might just create something else for y'all because I want it to be specifically for this and not just a bunch of other stuff. But that will also help you understand how to bring civil actions and how to sue yourself. And that's what I really want to do. But it's going, like I say, it's going to be a lot in here, and it's up to you, right? Yes, it is a $200 donation fee, but you got to think about it. This is something that's going to take away you having to pay a freaking $50,000 loan or a mortgage or whatever you're going to use this on, because you can use it on anything. I'm just showing you how I use it on dealing with it with my auto loan that I had. And I came out very successful. And, you know, I went back, studied, read everything about that particular case and situation, how I did things. And I critiqued it to where you don't even have to worry about over half the stuff that I had to deal with. And the reason why I like that, because it's like I get to go back and I get to study myself and study my opponent, and you know, the ways that they were trying to defeat me, I just perfected myself in those areas. So you can't come at me like that. And this is, I mean, I get a thrill out of it. Like, losing is not a bad thing in this particular stuff. A lot of y'all laugh at people because they lost the case or something. I wouldn't laugh if that person is very determined and truly then understands that, okay, now I got all my answers because I can see exactly what they did and how I lost and how I can stop them from coming at me in those ways, and I will win every single time on this particular subject matter. It's simple. So that's why I say, man, just study and like really look into it as well. What's up, Savage Life? But yeah, make sure that you look into it into a way that you can take control of this, because it's really not that hard, guys. It's just Read it. No more than you having to read some instructions to assemble something. Like, okay, read the instructions on, and then you assemble your petition or you assemble your procedure or whatever the thing like that may be, and just like then it's over with. And it's just one of those things that you gotta really just put your mind to and do it. Like if you want to win, you're gonna win and you're gonna do what it takes to win. Like, and it's okay to feel uncomfortable because once you get comfortable, it's over. Once you go through the fire, once you attempt, and that's all it took. Like, guys, don't be afraid. I lost court cases. I did. And you probably can look up my name. Like, what was he doing? Oh, ha, 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 ha. Just know that's the reason why I can sit here and tell you how to win and have won cases for a lot of people and myself as well. But it went through me just trying. I mean, it's no difference than you having to learn how to do something. You're going to fail at it first. Maybe you might not fail at it completely, but then like you can attempt something for the first time, but you still know you need to critique things because it could be better. So it's just one of those situations to where you get out there, you try, don't put yourself in harm's way. You know what I'm saying? Get you some guidance the best that you can, but hey, take it, go forward. Don't be afraid and win. Win, 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 win. All right. And if it's cool, like I say, just tell the people to test the theory themselves. Like me, I'ma always go first if it applies. A lot of people ask me stuff about mortgages, but bro, I don't I don't got a mortgage. I don't got mortgages and stuff like that. Right? Or I'm not or not mortgage, but foreclosure as well. But I'm not getting foreclosed. I'm not gonna put myself in a situation for my family even to worry or think about being foreclosed on. But I know people that do that, but I don't got a mortgage to worry about. No way. But my point is, hey, I can help you. I can show you where I've helped other people do it. And it's simple because I know the rules. I understand it. Take it for what it's worth. I can't show you a case where I had to beat me traveling around with 50 kilos under a drug charge. Why? Because I'm not going to do no dumb shit like that. So don't say, well, show me proof that you, no, because I don't put myself in certain situations. I can show you I helped other people. That's about it. But certain things, I shouldn't have to go put myself in a situation just to show you I know something. You don't go tell that lawyer to go in out there and shoot and murder somebody and let me see you beat a murder case before you represent mine. Don't none of y'all say that shit. You don't say that. You don't tell them to go prove this or prove that. Man, that lawyer might have about 50 losses, 100 losses under their belt. Ain't never won shit. Got a good plea deals or something like that, but we just pay him. You know a good lawyer? Yeah, the only lawyers in town. Ain't none of them worth a damn. But we going over there because somebody said they was good. But is they good? No. Oh, when you say a good lawyer, especially around small towns, what you saying is you saying the good old boy system. You know a lawyer that know a judge. Is basically what you say. Yeah, you know a good lawyer? Yeah, I know a lawyer. He knows a judge and knows such and such. Yeah, that's what you really mean when you say that. You're not saying he a good lawyer because he's a winner. You saying he knows somebody. He knows some things and knows some people. That's usually how I go. Yeah, I know a lawyer, good old lawyer that knows some people and da 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 da. And we can, move around some things for you. And that's pretty much what's said. So, I mean, you just got to take it for what it is, man, and just know, like, for yourself, guys, because ignorance of the law is inexcusable. Ignorance is what they're going to play up on. But the fact that they think that you're ignorant is how you beat them. The fact that they think that they get to presume that you don't know or they get to do all of this stuff to you, you're never going to check them. They look at it like they can get away with doing. I mean, how many promissory notes you think they did just this past week? They probably did millions of promissory notes, just issued out new debt, new money that's going to be brought into, far as Federal Reserve notes, and placed into the system. And look at that. Now, you got one individual over here that knows something and suing them. They still getting over on the other million of people. They'll take that all day because they're still going to win. And so they'll look at what you did, and as long as it's not like a full domino effect, then they're not going to worry about it. But if it starts happening and it becomes a full domino effect, then they're gonna find a way to change the way they do stuff, and it's cool. But at the same time, you can't change the human flaws. You can't change that, and that's if human got flaws, then everything they build is gonna have flaws. So I don't care how much you create technology to not have a flaw, it's already flawed because it does not have a way. It has to be controlled. It has to be thought for. It has to, it's glitches, it's this, it's that. So all of this stuff that continues to happen is a way to do stuff with it. So you got to be aware of yourself for real, y'all. And I'm like, and I know a lot of people just like read the law, study. Like, nah, read people. Know who you around, know who you dealing with, know who you involved with. When you hear the phone, you check the tone, check the person. Like you can, it's a lot that goes into this than just saying stuff. I mean, and maybe everybody don't think like me, but I bet it had you tripped up on that phone and you done said some of the most craziest shit you probably know you gonna get fired for. Everything goes. And I got a lawsuit on my hand before we get out here because I done got you all uproared and mad because I'm telling you something that you doing wrong in your job and you just don't. It gets pretty ugly, guys. I done seen people just cuss you out. I done seen bankers, the presidents of the banks cuss you out, saying crazy stuff because they just feel like they can. They feel like you're nobody. You don't got no money. You're a debtor. You're broke. You're poor. And you're stupid. You're ignorant. There's no way you can know more than me. I went to school. I'm a banker. Like, yeah. That's how they think. That's how they feel. Especially when you get those ones that come in there and they got that look on their face and they just smile at you. They're letting you know, yeah, buddy, we alrighty. We called the police. They called the police on your ass quick. And he came out there smiling and shit. You gotta watch them too. They do it. They do it. But I beat them. I beat them too. I beat them before calling the police. Straight up. If they do something that ain't right, that goes against the law or something like that, oh yeah, let me get this police report. Quick, I need to make this police report. Call them before they do. That's the reason why I tell y'all, sue them before they do. Y'all be letting these folks play with y'all though, man. It ain't no time for that. You have to show them. You have to show these people, and you have to mean business. But you sitting back, not doing anything, allowing anything to help you, to happen to you. Us going in, just signing, putting our name on any damn thing. We ain't read nothing. I don't care if the terms and conditions is 5,000 pages long. All you got to do, guys, is do one thing and one thing only. Turn around and tell them to read that shit and make you understand it. Either that or put it in layman's terms, one or the other. And I'm going to record your layman's term. Because if I make a decision based off what you read into me and try to make sure that I understand, then that could be still considered as misleading, deceit, and misrepresentation. Yeah. We still can hit you. I ain't no dummy. I ain't just going to sit up here. I'm going to say that, okay, you sure that's what this says? And da-da-da. Yeah, okay. Because you're still the one in control of telling me what this means or don't mean. But I'm just telling y'all, like, yeah, you ain't got to sign all this. They be like, here, sign here, sign here, sign here. No, I need you to read all of this and explain it to me. You know why? Because they the one that want to make the freaking sale. If you don't make a sale, your ass is fired, boy. Out of here. Quick. You know what I'm saying? So if that's the case, sit down and read it all. I want to know everything. Bring your dictionary too in relation to what the words, like who was the author of this and what was their intent when they put these words. Where's the definition so I can make sure that they mean exactly what I know for them to mean. Right? Are we legally speaking, or are we, how are we speaking? Webster Dictionary or Black Laws? Which one is this? Because I need to know what these words specifically mean. They have different meanings in relations to a Webster dictionary or than me using some type of Black Laws dictionary. So what are the meanings of these here? Just so I can be sure. And it's okay. They have to. But a lot of us just go in, I got the money, I got to get the credit, I'm signing and this and that, boom, we up out of there. The whole contract is really one-sided. And it is. The interest that they put on this money is freaking outrageous. care what nobody say. I don't care how good your credit is. I don't care if you can walk in there and ain't got to put nothing down and walk out. The interest is still crazy. And what I mean by that is the cost of credit. Let me say that. The cost of credit is insane. It's the cost of you're paying for the cost of credit because it's a credit sale. And since credit is costing you and there's a cost of credit, it should be no other form of money that has to be involved, meaning you shouldn't have to make a down payment at freaking all. It's pointless to even think that you should have to make a down payment when they are literally, right, selling the cost of credit to you. So why? What's the point? Right? And remember what I said about down payment. Nowhere in the particular contract is it stated that it is a mandatory down payment that you in order for you to get the car that you were getting and get the credit, et cetera, that you wanted to get, or any situation that you have to do a mandatory down payment. I'm already giving you the car in a secured as a secured interest in this transaction. As a security interest. So if I'm giving this to you as a security interest, why the freak would I need to even give you some money? It's stupid. I've already gave you something in consideration and in value, because what's the point of me giving you both? Can somebody make that make sense? Anybody? I think that is the most dumbest financial move that you can make. If you really think about it, make them make the choice. I'm already giving you the car as a secured interest. If you want to sell, there's no down payment. If not, then you guys have a nice day. I don't have to do this with you. And they'll let you go home, guys. And all you got to do is just be firm enough to sit there and don't say nothing, because they're going to call you back and say, hey, come, we've worked a way around that. Come get this car. And they know that because the money was already there. The bank was already going to be in lending of it as well. They just wanted the down payment for the payment for themselves as well. And they will do it. It's no point of it. Because why? What? In what other words? And that's the thing. Everything is already included in the finance charge, right? So if it's already included in the finance charge, then what are we talking about? There's no need for a down payment. Was a down payment included in the finance charge? Then whatever. They denied you if you didn't make a down payment. You ought to be suing the shit out of them. Because now they have to give a specific reason according to the let me see how I say it. They can't do it by down payment. It has to be something for specific reason. Because now if they denied you, right, what they had to send you a letter. So what letter did they send you on saying that they didn't what did the letter say? Because you could have literally went back to the underwriter and the underwriter would literally gave it to you. They would have probably like, hey, man, we'll send you a check personally. Just tell us how much the car costs. We're going to go around the dealership quick. And they will. Go to this branch or firm or whatever. I didn't see that happen before. But you just got to know. They didn't send me anything. Oh, you supposed to get them. It doesn't matter if it's in person or not. They still have to send you something stating on the reason why you were denied. That's part of consumer laws, right? They got to do that. Let me see if I can find what I'm looking for. All right, let me transition right quick and let me see if I can find what I'm looking for. I'm finna tell you what you were supposed to do. Yeah, let me go to I think we talked about this in season 7, if I'm not mistaken. Let's see. hidden evidence, power of objection, writ of warfare, credit, estate, that's commercial, bill of rights, reinstating. So I think we did that in season 6 then. Due process, breach means, mortgage means, mastering, money judgment, power to set off property law, credit denial. Here we go. So in the credit, reverse denied credit. So that's in my reverse denied credit book, right? And in my reverse denied credit book, ebook, it talks about what you were talking about. See, they have to tell you why you were denied. Yeah, they have to tell you, they have to send you a letter because what they're doing is interfering with commerce and they can't do that. That's a federal shit to do, you know? Okay, so let's see. You're into a commercial contract. There's equal credit opportunity act. It applies to all creditors, including banks, credit union, finance companies. The rule against discrimination. They can't do it off color. Let's see. Evaluation of applications. Notice of action taken. So this is critical. If your application is denied, the law requires the creditor to notify you in writing within 30 days of receiving the completed application, okay, with a clear statement of the specific reasons for the denial. A statement of reasons for adverse action shall be sufficiently specific to indicate the principal reasons for the action taken. So they have to let you know in writing within 30 days of the denial of why. And if they in violation, right? They cannot say you were denied due to insufficient credit profile, or they can't even say you were denied to a policy because you didn't have a down payment. That ain't got shit to do with the credit that was offered and extended by the bank. And notice that the dealership denied you, not the bank, because the bank specifically has to send it to you. Yeah, the bank specifically has to. If they deny you in credit, they have to send you a reason why. That's a fact. So these are not sufficient under law. You can demand a full explanation, a copy of the criteria used, a chance to cure or explain discrepancies. So you have to do that. If the creditor fails to follow these rules, they are liable. Any creditor who fails to comply shall be liable to the aggrieved applicant for any actual damages sustained and may also be liable for punitive damages not to exceed $10,000 in court costs and attorney fees. Okay, there you go. You got some work to do. They can't just deny you some shit and don't have a good reason to. So fix that. Man. That's what I be talking about. That they be stepping on our ignorance. But that's their problem. I tell y'all every day. Like, I promise you, man, we can go, I guarantee you, we can go to a dealership. And I promise you, they're going to violate the law some way. Guarantee it. Guarantee it. So, with that being said, that means also I would say 8 out of every 10 contracts of mortgages is flawed. And I'm going to say 8 out of every auto loan contracts are flawed. I guarantee it. 8. Say 8. I would say 10, but I don't think everything's always perfect. So they might find a way. But other than that, I know for sure that they're going to violate you some way. And they just violated you. If that happens to anybody, oh, well, if you don't got the down payment, you can't. No. I want you to show me specifically what the bank said that I have to provide this amount of money as a down payment. The down payment was just helping them or helping you. it don't help me extend to get more credit. I don't want to do that. I don't want to do that. So y'all need to understand that too. Right? So just know, man, paid in full, October 25th, 2025. All right. Yeah, paid in full, guys. As we just explained to you tonight, how to literally go to the courts, what to expect and what to do. But the rest is going to be up to you and following the procedures that we're going to have in class, guys. Don't forget, the 24th is the last day to sign up. Okay, get signed up if you want to get your title free and clear. And here's the thing, the work is already done for you. You just got to come in here and you got to walk it, guys. Exercise it yourself. It's already been done once before. It could definitely be done again. Someone actually done it before me. I just actually learned and started reading and heard what they said and say, let me put my own little twist to this. And that's exactly what I did. So you can do the same thing. Read more, read this, take this, add your twist to it to what you know, or just fully follow everything that has been fully laid out. But number one thing, read and also fact check everything that you're going to experience within this class, because it's only going to make you better and understand even more and find where it's at in your particular state on how to operate. So just know, we already got all the proof for you guys. It's already been done. As you're seeing right now on our screen is the proof. If you're on TikTok, just go to my page. It's there too. But the choice is yours, family. What are you going to do? Yes, you can do this with mortgages and other bills as well, but you just got to know the rules and fully how to apply it and walk that walk. Can't be afraid of court if you also are not comfortable with that. We also got the master in lawsuit class. So what I will do is I'm going to find a way to help benefit those who want that class, that takes this class. So it's going to be great to have you guys a part of this class and to exercise this class as well, man. More power to you. And the people I am about to get up out of here, share this video with someone. This will definitely help others to evolve as well. And I appreciate you guys. All right. Y'all have a great and beautiful tonight.